Welcome to the Santam Insure Your Future Money Bootcamp with me, Maya Fisher-French.
And me, Mapalo Maku. To give our listeners a bit of a background, we have been working with Santam staff members where we take them through a money bootcamp.
And last year, after seeing the amazing changes these individuals went through, we realized that there was an opportunity to take this money journey to a broader audience. So thank you very much to Santam for sponsoring this podcast.
We've spent the last few podcasts discussing building wealth. But what about succession? Who does that wealth transfer to if something happens to you? How do you leave a legacy?
I've uploaded such a key point, and that's why I wanted to talk today about, especially around the legacy part, because I know for you, for example, it's an extremely important thing. And for many people, they want to make sure that any of the money and wealth they've accumulated during their lifetime is used to go to future generations. And we want to talk about that. We want to talk about wills, estate planning, all of these really, really important things. So joining us today is Moremadi Mabule, who is a fiduciary expert, an expert on all of these topics, Mapalo, because you and I have both interviewed her and spoken to her over the years. And we're really thrilled to have you here, Moremadi. But let's start off with this concept of estate planning. This is a very big word, very fancy. We all think we don't need estate planning. Why do we, and why do we need to plan?
Thank you, ladies. Thank you for the invite. I really appreciate it. Estate planning sounds complex, and I'm going to break it down just to make it as simple as possible. So estate planning is you working hard, wealth creation. You've accumulated. Now you've got this estate. Planning for the estate to transfer to the next generation. And planning means you sitting down, you're taking stock of what you have accumulated and how you want to transfer it to the next generation, how you want the baton to move forward. See it as we're running a relay and now I want to pass it on. And you only do that through planning. So I like using an analogy of career planning. So you do your career planning. You know where you're taking your career. You do your estate planning because you know where your estate must end up. It's one of those things that people assume you can't plan if you don't have much. They think it's for the wealthy, and it's not. It's actually not.
I think that's very, very key, because even if all you have is a property, many people have properties, you still need to decide who that property goes to, what happens to that property, and it's about making sure the money you've worked for goes where you want it to. Otherwise, the government has you die into it and it decides how things are handled, which is usually a mess. But the other big part of estate planning is tax.
Yes.
That's something we all forget about. Like I said, the two-pot retirement system, everyone's really upset they're going to be taxed on the withdrawals. Just wait till they know that they're going to be taxed on death as well.
Yeah. You do not die for free, Maya. You do not die for free, unfortunately.
No. Tax, it's actually very expensive to die, so don't do it. That's my recommendation. So maybe unpack for us a little bit about the death taxes.
Yes. I like that you called it death taxes. So most of the time, and that's part of planning, when you're planning, you'll know that, oh my word, now I need to cater for this tax. It's called estate duty. Currently, it's sitting at 20%.
20%.
I want us to pause on the 20%. It's actually quite a lot. 20% goes towards estate duty.
Goes to the government.
It goes to SARS.
20%. Yes. That is a lot
20%
of money. 20% of your entire estate, what you've built.
Of your estate. But now, let's take it a step further.
But what about, is there not an amount that
Yes. The step further is we're looking at a certain amount. So it's a 3.5 estate.
3.5 million.
3.5 million.
Okay.
So on your 3.5 million, then it attracts estate duty.
Only after that?
Yes.
So above 3.5 million?
Above 3.5.
Okay, so your first 3.5 million... there's no estate duty.
There's no estate duty. Okay. And then above that, then it starts attracting estate duty. It can work out to be quite a substantial amount of money. But there are ways of actually, legally making sure that you plan properly and you move assets, that you don't grow your asset base above a certain amount. And there is a rollover effect if you are married. And I think it's an important thing to mention that, how you do the planning and you actually bequeath stuff in your asset base. If you are married and you leave stuff to your spouse, then there's certain exemptions.
But what if you don't want to leave anything to your spouse?
Which we know
most people don't want to do that.
Which we know most of the time. There's dynamics where people are saying, no, I'd rather leave it to my kids. If I'm married in community of property, 50% is his anyway. But then if the estate value now is above 3.5, then it's going to attract them the estate duty, and then we've got that rollover effect if it's going to the spouse, and then upon the death of second dying, that's when that estate duty 20% kicks in.
So I just want to be clear. So if I leave my entire estate to my husband and let's say my estate's worth 10 million as an example, it's a nice number. I leave it to him, there's no estate duty because he's my spouse, because we're married.
So we spoke about that rollover effect, remember? And as I said, 3.5 on an individual. Now we've got the 10 million. So which means we've got about 2.5 that is above that.
Okay. So let's just explain this carefully. So I pass away, I leave 10 million to my husband.
Yes.
No estate duty because he's my spouse.
Yes.
But he now passes away. His exemption, my exemption is 3.5 million. His exemption is 3.5 million, which is 7 million.
Then we've got that.
So then on his death, the first 7 million does not attract estate duty.
That's correct.
Only the 3 million left of that 10. Okay, so on that point, if he left it to the children, for example, the first 7 million would not be taxed.
So if you don't leave anything to your spouse, you leave it to your children. Then we're going to have that rollover effect. It's called a 4Q deduction. You won't get that 4Q deduction. But after that.
Yeah. So if I left 10 million all to my children, the first 3.5 million wouldn't attract state duty.
Yes.
But the remaining 6.5 million would attract 20%. So I think one of the strategies here, of course, is to leave an amount below 3.5 million to your children, which you leave estate duty free, and then the rest you leave to your spouse. So I think, you see, this is where
that could be a strategy.
This is where planning matters, you see.
This is where
you
the
can plan
planning,
for this stuff.
Yeah.
And retirement benefits, how does they not?
So the retirement benefits, so there's two different laws that applies. The retirement benefit is excluded. So the proceeds of your retirement, they are not coming into the estate. So they are payable separately. There's legal and the law that applies there is completely separate. But one thing that I want to emphasize there is a lot of people miss an opportunity to actually do make sure that their nomination forms are up to date.
The retirement funds.
Yeah, on retirement funds. So that's something that is quite important that we look at. That, when you're doing planning, you also have to go look there. I mean, there's a lot of people that first time they completed that form, it's first time of employment, and that's it. Life has changed. That thing could be outdated.
You get married, and then you get married to someone, and you discover his nomination forms, he's still got his mother there. Now, I mean, obviously, trustees have to apply certain rules. So I think that's quite a lot of people get confused with that a retirement fund is not part of your will.
Yes.
We'll get on to talk about wills just now, but your will doesn't determine your retirement fund. That is determined by the trustees who will have a look and say, we've got to give it to legal and financial dependents, and there's a whole lot of things. But what's interesting with your retirement fund is it doesn't form part of your estate, which means it's taxed differently.
It's taxed differently.
And it doesn't attract executor fees.
No, it's not. It's not in the estate.
But what if? I understand that obviously trustees will have to make a decision. But what if you just wrote the estate there? How does that work out? So let's say, for example, with your retirement annuity, you just left the estate. Let's say you just took out this retirement annuity without ever really having thought much about it. You don't have the right beneficiaries.
So let's take, for example, you take out a retirement annuity and you haven't put your children down as beneficiaries. The trustees come along and they say, how would that work?
So how it works, obviously there's that section 37C. So literally they sit and they go through case by case and they look at the, what we call financial dependence.
Yes.
That is what is important, and that's what's different between your pension monies and what's in your estate. So remember, in your estate, you can actually choose to disinherit someone But obviously there might be maintenance claim. But in this case, they look at financial dependence. Let's say you've got children, but in your nomination form, you've selected your brother, which a lot of people make a mistake like that to say, oh, my brother will look after my children. They never do. But let's say that is a scenario that you find in yourself with. The trustees are going to look at the best interest of the child, but they'll also look at the financial dependence. That's why we find Section 37C discussion happens. There is a ruling, this is how we're going to be distributing, and then we find out a couple of months later, there's another child somewhere, then we actually sit down and we entertain. Yes.
I think it's important. So children from previous relationships can considered as by the trustees.
Yes.
So
as they should. Those are your children.
So that's really, really important. And this can be a shock to some people who didn't know that there was a child from another relationship.
Yeah.
That can be quite a shock. But I like the point that you raised, saying the brother comes and they leave it to the brother, the trustees will relook at it. How does the trustee have a right to put the funds into something like a beneficiary fund to protect it for the minors if they're concerned about the adults around them?
So yes, so the Pension Fund Act actually does give the trustees those powers. So as indicated, before they make a ruling, they've done an investigation. And based on that, they could be comfortable to say, okay, we'd rather put this money in a beneficiary fund. So a beneficiary fund works like a trust. It's just that it receives proceeds from pension fund for the benefits of minor beneficiaries. It would work exactly like a trust. The child will get an income, which is a maintenance on a monthly basis. But I want to reiterate something that, that really breaks my heart when it comes to beneficiary funds. And that's why I'm worried about the two-pot system and people going in to actually take in money out of their pension monies, because when you sit with beneficiary funds, a lot of times you have to reiterate to clients that we received what we received, which is what your parent saved.
Wow.
Sometimes it's just 50,000.
And that's all the kids got.
And that's all the kids got. And unfortunately, there's an assumption when somebody passes away that they've left money.
Yeah.
And that's not always the case.
Unfortunately, they've been drawing out their pensions and it isn't actually. I want to go back because I wanted to go a little bit into the retirement funds because that's important. I think a lot of people don't understand that. But I want to go back to the estate planning and the will. And we spoke about estate duty or death taxes.
Yes.
But the other one was a huge shock for me when I did my numbers was executive fees. Because executive fees are what, 3.5%?
It's
Add VAT on.
3.99%.
Add VAT on and you're
That's
at
3.99%.
3.9, so call it 4%.
Yeah, it's
so
4%.
4% of your entire estate. There's no exemption like this 3.5 million. It is from the first rand.
Yes. So I think it's a shock for a lot of people. And the only time you'll know and do that proper calculation is when you plan. So we're addressing and dissecting on that estate plan. So executors' fees, it's something that you can actually plan for. Know how much it's going to be due and payable and plan for it. Number two, you are able to actually negotiate upfront, and people don't necessarily know that you can negotiate upfront for executors' fees. I always encourage people, put it in your will. But you can only plan for it, negotiate for it if you draw up a will.
Do the will.
This is another reason to have a will, so that you can negotiate the executive fees.
Because
Absolutely,
if you pass away and you don't have this thing, how you're going to pay the 3.99% either way, isn't it?
Look, there's also the school of thought that says, if I don't nominate anybody as an executor, I have a will, I don't nominate anyone as an executor, and I pass away, my children can go knock at all these companies and negotiate. They don't have to wait for anybody to pass away. It's already an estate. That is what other people are doing. That's why there is a big movement of people leaving spouses as executors of each other's will. Because then they take that will, upon the death of the first dying, they go and negotiate. But it's because they've planned.
Yes.
Okay.
Yeah, I mean, I must say that
planned.
is my husband and I are executors on our own estates, and then we will go and use, go and find the person to wind up the estate and be able to negotiate.
You can negotiate.
But I mean, so that's in one way. But the other way, of course, is that you may not have a family member you can trust or feel competent enough to be the
To
executor.
do it, yeah.
And then you could nominate someone, and that's where you could negotiate a fee and put it in the will.
Yeah.
So you could stipulate it in the will.
You can say, this is my estate value. This is when I'm looking at it. It's a straightforward, everything to children or everything to spouse, failing spouse to children. I want you to do it at this percentage. Other people are quite eager and, to do it that way. And you put it in your will.
Now, let's talk about kids and leaving some sort of legacy for them. We often say, okay, with your employee benefits, you'll probably have life cover on there, approved and unapproved life cover. Or as an individual, you can have life cover by yourself. Is it wise to go leave little more 50% and Mulimo 50% in there when they are minors?
Yeah.
Well, what happens to that money?
Yeah.
So I think, there has been a lot of changes, and industry practices have also kind of evolved. So my answer a couple of years ago would have been, if you do that and he's 3 years old, what was going to happen? It was going to go into the guardian fund. But now what happens now is that when the insurance houses see the nomination and they see it's a 3-year-old, they will actually engage the guardian. But it gets dangerous. Because imagine now the guardian is the one that's going to receive the money.
How do you make sure that the money's used correctly? And I suppose this depends on your relationships, right?
Absolutely.
If you're married and you trust your partner.
But again, what she's saying, it's truly going back to when you do your will, you would have to mention a guardian in there, right? It must be someone that you fully trust, that, this person will take care of my kids in a way that I know. So a will is such an important document.
So, Moremadi, you and I had this conversation. I had a woman who said, she's putting down this person as her guardian or as a mother or something. She said, but I'm not sure if I should tell her that she's a guardian because, there's this fear that someone's going to kill you for money. And you were saying, well, don't put down somebody as a guardian who thinks going to try and kill you. That would be definitely a reason not to make that person your guardian. Yeah. So I think this is the selection of the guardian is very important. But is there a way you mentioned the guardian fund, which is this government-run thing, which is just don't go there, right?
Yeah.
But is there a way to have something in your will that protects the assets for your children? So you have a guardian who looks after them and all that, but isn't now in control of the money, because not everyone's good with money.
So sort of a trust, Maya.
Yeah.
Something like that.
So that's where planning comes in. So if you do a proper estate plan, you're going to look at the needs of your children. We've got a 3-year-old here. We want to leave 3 million proceeds of a life cover for them to obviously educate them. What you need to now to do, you can set up what we call a testamentary trust. Okay. So there's a school of thought that says, if I am taking up this life cover and I'm saying it needs to be payable to the trust, then it must via the estate, then it's executor's fees. So we plan. Okay.
So if the life cover goes into the estate, it will attract executor fees.
Yes.
But I think you can exempt it, or
so if now we don't want to come into the estate, you see, so we need to find a different vehicle, and you can only do that if you're planning. Okay, so we now have a 3-year-old that we want them to be a beneficiary of this, so we can create what we call a guardian trust. So remember I spoke about the guardian fund that's sitting at the master. You can create a guardian trust this side, which receives proceeds from life covers. Okay.
And is that different from a testamentary trust?
It's different from a testamentary trust.
What is the difference, and why would you encourage me to open one over the other?
So it depends of what's in the estate as well. I'll give an example. A lot of times we would do the planning. We set up a testamentary trust. Upon the death of the testator, the only thing that's really in the estate is a fixed property. So how is the trust going to run without liquidity? So sometimes we sit with that problem. And if we via that money via the estate, it will attract executors' fees. So sometimes you go the other way just to protect this.
And does it last for as long as the child is what age? Do you prescribe to say
age of 18. It's the age of 18 in the guardian trust. So in the testamentary trust, you can actually keep it to whatever age that you think is
until they
appropriate.
finish university, that sort of thing.
But I think there is so many other products in the market. Once the child turns the age of 18 and they feel, I don't want to take my cash, I'm going to move it to...
But who at 18 wouldn't want to take their cash?
You'll be surprised. Nowadays, I think financial literacy is slowly lending. It's slowly lending. So you ladies are doing a great job. It is slowly lending. You'll be surprised. There's people that were saying, I'm not ready for this money. Please keep it somewhere. But I still want to get my income every month.
But who runs the guardian trust?
So some financial institutions do have the guardian trusts.
Okay.
Yeah.
So I've heard of beneficiary funds, which is where the trustee, the pension money
pension.
goes.
Yes.
So now there's something called a guardian fund as well.
Guardian trust.
Sorry, guardian trust. Mix them up.
Trust.
Guardian funds run by the government. Guardian
Yeah.
trust. Okay, that's worthwhile. And I mean, obviously, all of this is determined by this very, very important document called a will. And what I wanted to do, it was very interesting. I mean, I had somebody contacting me saying, "I've got a will. I've signed it, but nobody witnessed it. Is it valid?" And I think I'd love to go through with you kind of the mistakes people make around their wills.
Yeah. One of the things that a lot of people make mistakes is not understanding the validity of a will. What makes a will valid? So let's start. It needs to be in writing. There's been very interesting things. People would be saying, I'll do a video will.
Yeah, all on TikTok stuff.
Yes. There's video wills.
Don't even get me started
There's
on TikTok.
all these other things that are interesting. But at the moment, the Wills Act is very clear. It needs to be in writing. It needs to be signed. There's always, and when I say signed, it needs to be properly signed in front of two competent witnesses, not the second witness as an afterthought. Because that, when there is a dispute, it does become a big issue.
So they need to be sitting, the three of you need to be sitting down in one room at the same time on the same date and sign it looking at each other.
Absolutely.
Goodness, okay.
The Wills Act doesn't talk about a date, but you want your will to be dated. So you'll see in most cases a template of a will come with a portion where it says dated at. That is important. The only thing that it is important for is to see which one is the latest will. Remember, in the will document, the first clause is normally the revocation clause, meaning I'm revoking the previous one with this one. But now, if we've got all of them not signed, which one is the latest one? So that is something that people need to be mindful of. We do get a lot of times where, okay, the person has passed away, this is what we find. We don't know if it's the latest one. And then the latest one comes and we're like, okay, how do we prove? Becomes a bit of a court issue that needs to be resolved. The last thing, those witnesses, Mapalo, that we mentioned must be in the same room, should not be beneficiaries mentioned in the will, nor should their spouses be mentioned in the will.
Or not their spouses.
No, their spouses.
Okay.
I did not know that part.
That's interesting. So if you've got, if it's your, so you can't have if you mention your brother, you can't have your sister-in-law signing as a witness. Okay, that's interesting. It's a good one to know.
Yeah. And also the executor. There's always that thing that the executor, you nominate Maya to be the executor of my estate, and then she signs it as a witness. She can't be a witness. There's another key point when it comes to signing that we actually miss out a lot. I've heard people asking me to get a will signed, some so-and-so is on their deathbed, they can't, and then please, we just need somebody to, so you need a commissioner of oath so that they can be a certificate of commissioner of oath. That person can thumbprint and all that. But when I say somebody's on their deathbed, they need to be mentally present. They need to really know what they're signing, because we do get, unfortunate situations where people take advantage of other people.
And that's actually really important, because also you cannot, that comes into the whole power of attorney, and it's another whole episode, but you cannot have power, like say you have power of attorney on your mother. If your mother has already lost her mind, you can't get power of attorney. You can only do it if you're competent. So I think that's very important. That if the person you're getting the power of attorney on for is mentally competent. You can't do it after that. So anyway, just a
yes, and also on the power of attorney, people need to know. I've had, children calling my mom. I'm the power of attorney on my mom's estate. I need to do this. I want to change her will. You can't do that.
No, power of attorney doesn't mean let you change the will. No.
You can't do that. Yeah.
So let's talk about going back to kids. Not kids. Let's say yourself, right? How important is it? Because I think we don't think about this enough, that you're healthy right now, but what if you get into a car accident and you become mentally incapacitated? How important is it to mention something like that in a will, to say, should I be in a coma for whatever? Do those type of things apply?
A living will. That's called a living will.
Yes. So there is a living will that people can actually opt for. And it's always very tricky in terms of its legality. So you getting to draw up a living will, you sign it, but your family might decide, we're not doing this. And they might, there's always that wrestle. However, it makes it easier when it's done, because that's what your wishes were.
It's like, do not resuscitate, or do not keep me alive by artificial means.
Yes.
We've all got one of those. So we've signed those ourselves. I've got them in my will.
See, I think that's very important.
Because it also gives direction to the family,
absolutely,
I think, and to the doctors and things like that. It's a little bit morbid, but
we're thinking, might as well. I mean, you're doing a will.
So we've spoken about the will, what makes a will valid. You must sign it and have 2 witnesses present, all wet ink, right?
Yes.
And we've spoken about, we didn't go too much into testamental trust, but that is a trust that can be formed within your, I mean, I certainly have it for my kids. It falls away because they're nearly both of age now. They're much older. But, I mean, do you have a will with testamentary trust?
Yes, absolutely, Maya. Absolutely. But then I think going back to what Moremadi was saying about liquidity, that planning is really about saying, is there enough money for the things that I want, especially for a testamentary trust? Because it costs money, right, to run a trust.
It does.
And also property, fixed property. Should you be leaving fixed property to children?
So I think the main thing from a planning perspective, nothing wrong with leaving it to children. Just make sure there is sufficient money. It's not the only asset that you're leaving to children. That's the first one. I think the technical challenges with fixed property is it's illiquid. You're stuck with this thing. And you might have 3 children. The one wants to go live in Australia. They don't want to be here. They don't want to be stuck and married to this property. And the other 2 don't want to sell. Then what? Location is also quite important. Where is this fixed property? Because you could leave it somewhere in a prime area now, but at some point they're like, we don't want to live here. Then what? It's got that and maintenance of it. Can they really afford now the upkeep of this fixed property? That's another thing. So that's quite important. But this is where the trustees come in. If they're still quite small, the trustees will look after the asset. The trustees don't look after the asset for free.
Yep.
No, it's fees.
It's
costs.
It's fees.
And could you give an instruction to say, on my death, the property is to be sold and then distributed among my children?
Yes,
so that
absolutely.
Is what,
part of your planning. That's what you can decide.
We actually did that with my mother. My mom had this dream that her house in Hartbeespoort Dam would be left to the children. All that. And we're like, none of us live there. But she had this in a picture in her mind.
Yes.
And fortunately, she had the discussion with us, and we said, but
we don't live there.
No one wants to.
What? It's a holiday home. Like, it didn't make sense to us. So she put it in her will that on her death, the property must be sold and the proceeds then distributed.
Yes.
So, and I think that I just think so many of these things are better off with conversations.
Yes.
Yes.
But that's where there is the gap. And that's why I think when I said financial literacy is slowly dropping, people are slowly getting comfortable to talk about these things. But it's very tiny percentage of people having those conversations.
And getting advice. And I know you can get a will for free, but it's not for free. Because if you get a will signed for free, it's usually the executor and all the rest of it. They'll make their money on the executor fees. How important is it to maybe actually pay someone to draw up a will for you properly that takes all of these elements into consideration, all these things that we've just discussed. And what do you expect to pay, and is it worth paying for?
Yeah. So I personally wouldn't, go and take up a will that is a template somewhere on the internet, because I haven't done proper planning, but it's a start. So I would say start. Okay, let's start there. At least there's something.
At least there's something.
At least there's something. Yeah. The second thing that, what is of value? I make my financial advisor the same example as me going to the doctor for my annual checkup, going to the gynae for the annual checkup. I'm getting value for my money because I know annually this is done. Then we move on. So the same thing as sitting with your financial advisor. Your financial position might have changed. Bought a new car, bought a new house, birth of a child, something changed. Sitting with your financial advisor gives you an opportunity to actually plan properly and having that kind of a conversation. Financial advisors, do we talk about someone who's a policy trying to sell you a product only? No, we want somebody who's going to holistic approach to say, okay, Moremadi, this is your age, this is your children, this is where you're going. How do we get you there? And based on that, they're able to actually look at your will holistically and plan for it. How are they remunerated nowadays? I've seen financial advisors that advise based. So they charge a fee for their time and they come with a plan. And that's where you get value for your money. And I'm not saying the ones that actually do the advice for free, they follow a different REM model. And that's also fine as long as you get a proper plan. Yeah.
And I think also you can go to a lawyer. A lawyer will draw up a will for you. They'll charge you for it, but they'll draw it up for you. And I think it's one of those things, we've spoken before about, when you're getting married, you spend all the money on the wedding and the dresses and all that, and not spending on a lawyer to draw up a proper marriage contract.
Yes.
And I think, it is worthwhile. And even if you, I suppose if you're young and you don't have many assets and you just have the template, it's not the end of the world. But I think the minute you have children, go and go and have a proper person look properly at your will. They don't even have to be the executor, or if they are, you can negotiate, or you can make your spouse or whatever executor, but pay for that expertise, because it's going to save your family so much in terms of tax even. Think about it as an investment and not paying SARS.
No, absolutely. And it is. Yeah. And back to my analogy about, a relay running. When you're passing on that baton, you don't want to leave it with all the baton.
Yes, yeah.
You want to make sure they're able to run. But So
can I tell you an example, Maya? I think for me, this was enough motivation to get a will done. During COVID, when everyone really was battling and people were dying, this guy says the mom passed away first. 6 months later, the dad passed away. And the person that they had their wills with
passed away.
Took 3.99% on the mom. 6 months later, it was 3.99% on the dad's one. So it is very important to look into that executor fee and negotiate, as Moremadi said.
And in that kind of a scenario, unfortunately, the person that was doing the estate rightfully took up that fee, right, for both estates, because that's what is allowed, right?
It was legal.
It's legal.
Maybe
it's
not
legal.
ethical.
Not
but it's
ethical,
legal.
but it's legal. Because maybe even the second estate, it was just a quick, nothing really, because the bulk of the work you did with the death of the first dying. But a lot of people upon death of the first dying don't change their wills.
And update it.
Update it.
So, I have a question on marital contracts. So let's say you were married and you had your partner in your will, of course. Then let's say you get divorced. 3-6 months later, you still haven't changed your will. Does that person stand to benefit still?
Yes, that's your wish. Because you've got 90 days to actually go and amend your will. 90 days is sufficient. But people don't. Your life-changing circumstance, divorce is a life-changing circumstance. Marriage is a life-changing circumstance.
No, it's really important. I mean, it's very, very important to update your will. You know, we review our will, even though nothing specifically major has happened, just because it's just good to refresh. Your assets change. Now your children are older or something happens. You know, you just want to understand continuously what it is.
Absolutely.
I do feel like there's a lot of admin around money, Mapolo.
There is, Maya.
I mean, we speak of your life insurance. You've got to review your life insurance, your investments, your medical aid, your will, your budget. It's a lot of work, which is I think why people don't do it.
Yeah.
And I understand and I have great sympathy because it does feel like a lot of work. But this is why we do these podcasts, and hopefully people will take time out. And even if you just in your diary now, just put a date in to go review your will, go speak to someone about it, and get it sorted. Yeah.
But the beauty about it, Maya, with all of the stuff we speak about on this podcast, the budgeting, the life insurance, investments, is that once you just get it done, that first time you just get it done, it's a weight off of your shoulders. Then the reviewing is slightly better. I always find that it's that first initial action that people need to take that takes a bit longer. But once you're there, it's much easier to get into the groove of things and know that, okay, I need to review it as and when my life changes.
Yeah,
Great.
Yeah, that's correct.
Well, I want to say thank you so much, Moremadi, for just brilliant insight. Mapula and I have learned something new about the Guardian Trust. It's a new thing for us both. So look, that's why we always chat to you, because we learn something new. I do think there's another. You and I have had so many chats about life partners and all of the changes that are coming around that. So maybe another podcast for that one. But thank you very much for your input. And I just think, to sum it up, please at least go get a will, because planning saves your family money, and why give away more tax than you need to. I think the tax part's what's going to make everyone go up.
Yeah. They're going to look at their estate. But I wanted, before we would close off on the tax part, one thing that a lot of people, I know, the buzz is back, where people are saying, I'm moving my asset into an IV trust. It's back. People are moving their assets into Intervivo Trust. That is a nice tool done properly to actually try and not grow your asset base from 3.5. So you leave it at 3.5, you start growing.
I know, but there's a lot of tax implications within a trust. I mean,
is it 40%?
It is. If it's receiving income, a whole lot of it's taxed quite high, but the buzz is back again.
Okay. Well, I don't know. Maybe that's the next podcast is whether to have a trust or not. Because I'm a little bit dubious of it, to be honest. I think they are not that flexible and not that. I think SARS has made sure that trusts are not what they used to be.
Absolutely. And there's a lot of administration. So I want people not to, when they move and say, okay, I'm worried about this 3.5, let me do the planning, then next advice they're going to get is grow it elsewhere.
Yeah.
And then let's just check if elsewhere is exactly what
or you must just accept that there's going to be tax. And just budget for it.
Yeah.
Anyway, Moremadi, thank you so much. And we'll definitely have to look at some of the other these hot topics, because I think we could have been here on for even longer. I know it's been quite a long podcast, but it really has been interesting. So thank you.
But very insightful. Thank you so much, Moremadi.
Thank you, ladies.